And for the record, my name is Lukwago, my lord. Regarding the first prayer or the order sought, my lord, I would like to refer this honorable court to the authority of Besigye Hassan versus the Attorney General. It's Constitution Application number 9 of 2013, where the Constitutional Court held that stay of the proceedings like in the instant circumstances, my lord, is a constitutional command. It's a constitutional command. They grounded their finding, my lord, on the provisions of Article 137, 6 and clause 6 and 7. And this is what they had to say, my lord. This is what the Constitutional Court had to say, my lord. It is right that once a party challenges the constitutionality of his trial by the trial court, the trial court has to stay all its pending criminal proceedings emanating from the impound proceedings until the disposal of the constitutional petition. The operative phrase from this decision, my lord, is the trial court has to stay all its pending criminal proceedings emanating from that particular session case. It's our submission, my lord, that this court is bound by that decision. For reasons which have been explained, my lord, in a plethora of authorities. And my lord, permit me, as I conclude on that particular point, as far as the rationale is concerned for that particular decision, to refer you again to the Supreme Court decision of the Honorable Theodros Sechikubo and the 3 others versus the Attorney General and the 4 others. It's Constitution Application number 6 of 2013. Same year. where the Supreme Court had the occasion to state, thus, it is the duty of the court to make such orders as will prevent the matter, if successful, from being nugatory, from being rendered nugatory. Our contention, my lord, that if you do not stay the proceedings, the constitutional matter could be rendered nugatory. And my lord, my colleague, the honor, I mean, my landy friend, Ernest Kalibala, has already succinctly explained that the gist of the constitutional petition. But for emphasis sake, my lord, just for emphasis sake, that the right to fair hearing under Article 28, which is non-derogable under Article 44, constitutes the thrust of the matter before the Constitutional Court. So if, my lord, there is no stay, and it happens that the constitutional petition succeeds, my lord, there will be a derogation from the right to fair hearing, which would amount to an egregious abuse of Article 44 and 28. Most so, my lord, when the constitutional petition touches the critical issue of the competence of this court in trying the accused persons. It's only fair, just, and reasonable that, my lord, this honorable court stays the proceedings, awaiting this decision of the Constitutional Court, considering those imperatives, my lord, which we have highlighted earlier on, raised in the recusal application, which are the thrust of the matter before the Constitutional Court. My lord, on the second order sought, I would like to state, my lord, that the two orders are inextricably intertwined. The two orders sought are inextricably intertwined. One follows the other. My lord, once the proceedings are stayed, the next question is, what happens to the accused person's right to bail or liberty? First of all, there will be no order for their appearance before court again, because remand cannot be indefinite. I know one will contend that no, there will be mention, even if that were to be the case, my lord, that there would be mention of the case, the applicants or the accused persons will stay in Luzira as lodgers. And my lord, your brother Justice Masaru Museni was once faced with that intricate and unique situation in the case of General David Sejusa Munungu versus Uganda. Its High Court miscellaneous application number 38 of 2016. Criminal this very division, my lord. I've got a copy, my lord. My lord, because of its significance and bearing on this matter, I will proceed to page 4 of this decision, my lord. Where Justice Masaru Musene posed a number of questions. Actually, there were 7, but I'll just read the 3 to guide the decision that he made, which is almost on all fours with the present situation. He said, however, despite the suspension of the charges, the applicant is on remand and has been directed to apply for bail in the criminal division. Then he asked, this is rather a novel situation which has not arisen before, and there is no known laid down procedure to deal with it, or not other with an application for bail where charges against the applicant have been suspended or stayed. The crucial question is therefore, does this court fold its hands and send back the applicant on remand in Luzira, and yet the charges over which he was remanded have been suspended or stayed? And if court is to fold its hands, won't that make the order of the High Court by Justice Ouma Oguri redundant? And finally, why should this court fold its hands and send back the applicant on remand, yet Article 139(1) of the Constitution, along with the Section 14 of the Judicature Act, grant the High Court unlimited original jurisdiction in all matters? He concluded by saying on page 5, in the present case, therefore, even if there is no appeal or reference from the General Court Martial, because the original matter was before the General Court Martial, even if no, in the present case, therefore, even if there is no appeal or reference from the General Court Martial, this court cannot fold its hands and chase away the applicant from the temple of justice. I shall exercise this court's powers under Article 139 of the Constitution and Section 39(2) of the Judicature Act to consider the bail application by the applicant. And he cited Section 39, which, my lord, under the revised edition, is Section 43 of the Judicature Act. For material, my lord, that particular provision applies in the present circumstances. And the final decision he made, as I read, bearing in mind the law as outlined above, that is after citing the relevant provisions of the Judicature Act, the judge said, bearing in mind the law as outlined above, and in further considerations of Article 126(2)(e) of the Constitution, which empowers this court to administer substantive justice without undue regard to technicalities, I find and hold that the circumstances of this application warrant meritorious consideration. The offences with which the applicant is charged are bailable by this court since the proceedings in the General Court Martial have been suspended pending the disposal. My Lord, General Sejusa was accordingly granted bail, cash bail, actually on his own recognizance. Much as I was a surety in this matter, as you will see, my Lord, in this particular text, on his own recognizance, 10 million, not cash, just on his own recognizance, despite the gravity of the matter and the fact that it was before the General Court Martial. So, my Lord, in this particular case, we have gone an extra mile of presenting substantial sureties, of bringing out the profile of the applicants, which are all compelling reasons, my Lord, under the circumstances. But the crux of the matter, my Lord, is not to leave the applicants as lodgers in Luzira, because that was the issue here Justice Masaru Musene had to deal with. So once you have stayed the proceedings, it's axiomatic that the right to bail has to follow. My Lord, we do pray that you be pleased to apply, rather to follow this very good precedent set by this very division to admit the applicants to bail after ordering stay of the proceedings. We do so pray, my Lord. And my Lord, you don't have no idea as to when the Constitutional Court will dispose of the matter. You have no idea. It may take a year, it may take 2 years, or a month, and it's the reason, my Lord, in Article 137, Clause 7, the framers of the Constitution made a command that proceedings be handled expeditiously, but we don't know as to when the matter will be disposed of, and that will be injurious to the rights of the applicants. We do so pray, my Lord.
Very briefly. May it please the court, in the hierarchy of courts, the Constitutional Court is higher than this court. It's therefore reasonable that this court should give way and order a stay awaiting the verdict of the court, of the Constitutional Court. Especially so because the application which has been made in the Constitutional Court emanates from the refusal of this court to recuse itself, the dismissal of the application to recuse, and hot on its heels, the refusal to refer the matter to the Constitutional Court. Justice is about appearances. It should not only be done, but be seen to be done. And the question is, what would operate on the mind of a reasonable person following those two incidents? And also the fact of the petition filed by A1 and A2 before the Judicial Service Commission. Would a reasonable person think justice has been dispensed? I would like to persuade the court not to let any reasonable person think that this honorable court would wish to preempt the decision in this matter. Quickly moving on to the second point, the presumption of innocence, which is in the Constitution in Article 28(3)(a). A1 and A2 are presumed innocent until proved guilty. And the right to bail actually stems from this presumption of innocence. To let nobody go against this constitutional imperative by wanting to imply any guilt on the part of A1 and A2, because the Constitution rejects any such notion. I ask the court not to lose sight of the fact that they have spent 13 months in jail, over 13 months. 1 year ended on the 15th of November, and it's past the 15th of December, so already 1 month, 1 year, 1 month, and we are now entering into the second month of year 2. The court should use its inherent jurisdiction to grant bail, noting the lengthy time this matter has taken, and also to take into consideration the age, especially of A1. And age is one of the consideration in bail. As to whether there are flight risks, I just want to comment that the bail, not the bail, but the application, the documents that annexed to the application, especially to the supplementary affidavit of A1, shows that he had previous cases of treason. This is not the first treason case. In both cases was admitted to bail. Thank you. And both cases he attended court as required until the prosecution either dropped the case until the conclusion of those cases, whatever the way. And therefore, he has no criminal record. None of them has a criminal record. And just to describe what advanced age means, it means anyone of 60 years and above. I therefore myself qualify as advanced age, and A1 qualifies as a person of advanced age, and A2 as well. So really, the court ought to be persuaded by this fact. Finally, and before I go to the final, I've been looking at Article 126, exercise of judicial power. To begin with, it's the right from the people and shall be exercised by the courts established under this Constitution in the name of the people, in conformity with the law. And that is why appearances matter, because this court is accountable to the people of Uganda. The prolonged incarceration of both A1 and A2 is causing great concern. I can say that from the bar. It's a matter of public notoriety. that the highest authorities in Uganda have expressed concern about the prolonged incarceration, and I'm urging my Lord to take judicial notice that none other than His Excellency the President of Uganda has expressed concern. It's been in the papers. So I can say confidently, standing here, that the people of Uganda, including the people in this court, are very concerned about the prolonged incarceration. I would urge you, because this case is right, for grant of bail. I am impressed by the sureties presented, and I'm urging the court to be persuaded that suitable sureties have been presented, and that for justice to be done, let A1 and A2, let them not spend a second Christmas in incarceration. That would go against the presumption of innocence. I pray that the court exercises its discretion in their favor and grants bail. And I associate myself with what my eminent team had already submitted. We are most obliged, as I had indicated. If a paper is passed around, we will. Do you want us to give the email? Okay, we can write down if a paper is provided, or they are already doing so. So, my lord, if you allow me, I could first begin with a request that you allow us, as when the court adjourns, to see our clients for 45 minutes inside this courtroom. Okay.